Heirs versus beneficiary in Georgia. When it comes to estate planning, understanding the terms heirs and beneficiaries is essential. These terms often come up in discussions about how assets are distributed after death. Though they are sometimes used interchangeably, they have distinct legal meanings. Knowing the difference can help you plan your estate more effectively and avoid potential disputes. Under Georgia law, heirs are individuals who inherit a deceased person's assets by default, usually based on familial relationships. On the other hand, beneficiaries are those specifically named in legal documents like a will or trust to receive certain assets. Let's break down these distinctions further and why it's important to understand them in estate planning. Georgia laws regarding heirs and beneficiaries. In Georgia, the distribution of assets can vary depending on whether someone dies with or without a valid will. If a person dies intestate, meaning without a will, the state's laws of descent and distribution will determine who inherits their assets. This is where the term heir comes into play. Heirs typically include spouses, children, and other close family members, in a prioritized order established by state law. Beneficiaries, however, are designated by the deceased through legal documents. These individuals or entities, such as charities or trusts, are named to receive specific assets. It's important to note that beneficiaries don't need to be related to the deceased. They can be anyone the deceased chose, including friends or organizations. Georgia estate planning laws also differentiate between probate and non-probate assets. Probate assets are distributed according to the will, while non-probate assets, such as life insurance policies and retirement accounts, go directly to the named beneficiaries without court involvement. Properly designating beneficiaries across all legal documents ensures that assets are distributed as intended and helps avoid unnecessary legal complications. WHO inherits your assets in Georgia? When someone dies without a will, Georgia's intestacy laws kick in to determine who inherits the assets. The spouse and children are typically the primary heirs. If there are no immediate family members, the assets may pass to other relatives, such as parents or siblings. The law firm handling the estate will follow a specific order of succession to distribute the assets. In contrast, if someone has a will or trust, the assets will be distributed to the named beneficiaries according to those documents. It's crucial to keep these documents up to date to reflect your current wishes, especially after major life events such as marriage, divorce, or the birth of a child. Failing to do so can lead to unintended outcomes and potential disputes among heirs and beneficiaries. The estate planning process, heirs versus beneficiaries. Estate planning involves more than just writing a will. It requires careful consideration of how your assets will be distributed to both heirs and beneficiaries. Heirs automatically inherit assets when there is no will, while beneficiaries must be explicitly named in legal documents. Trusts are a valuable tool for estate planning, allowing you to set specific terms for how and when beneficiaries receive their inheritance. This is particularly useful if you want to provide financial security for a loved one while maintaining control over the distribution process. Proper beneficiary designations on accounts such as life insurance policies, retirement plans, and payable on death accounts are essential to ensuring your wishes are carried out. These non-probate assets can bypass the court process entirely, streamlining the distribution process and reducing costs. It's also worth noting that beneficiaries can decline their inheritance if they choose. This can happen for various reasons, including personal preference or financial considerations. In such cases, the assets will pass to the next eligible beneficiary according to the estate plan or the state's succession laws. Trace Brooks Law, located at 1275 Peachtree Street, Nebraska, number 525, Atlanta, Georgia, 30309. Can provide personalized guidance on navigating the complexities of Georgia's estate laws. Whether you need assistance with creating a will, establishing a trust, or understanding your rights as an heir or beneficiary, Trace Brooks Law is here to help. Call us at 404-492-9559 to schedule a consultation today.